hearing in the appeals, Benkharbouche and Secretary of State for Foreign Commonwealth Affairs, and Libya and Janah.
My Lords, my Lady, I hope there are two documents from us before you that we produced overnight.
Yes, thank you very much. There are.
One of them is headed Response to Secretary of State's Table, recording assertions of immunity, and one of them is headed Respondent's Supplementary Note on Article 14 and Section 42B. I hope that their production will further ensure that I finish well within my allotted time this morning, and I'll speak to them each briefly in a moment, if I may. Could I also hand up my Lord Clerk a clean copy of the Secretary of State's original?
Actually, I found it.
Oh, you found it. Thank you, my Lord. In that case, I'd like to go first to our response document to that table, the first of the documents I mentioned, and emphasise a number of points that we've set out there, some of which I addressed yesterday when dealing with the question of assertions of state immunity and their significance or otherwise in the context of state practice. The first point is that set out at paragraph 3, just to put some numbers on the general assertion I made that a significant number of the states in the tables, in the Secretary of State's table recorded as having asserted immunity, actually had domestic law which would not afford immunity in relation to domestic worker claims. And we've given the figures at paragraphs 3 and 4. 15 of those, of the 27 states identified, as a matter of their own domestic law, would not bar claims by domestic workers. In relation to the other 12, there's no information before the court as to their domestic case law in relation to 11 of them. And as to the 12th, we know from the 12th being South Africa, this is paragraph 4, we know from the contribution of the South African delegate in the drafting process of the UN Convention that he was opposed to...
Yeah, you told us that yesterday.
Yes, so that's that point, my Lord. Then at paragraph 5, we've dealt with the point about on what basis is immunity being asserted, because one could only draw significance from this line of argument for the Secretary of State's purposes if he could show that immunity was being asserted on the basis of some blanket ban on claims, rather than, as we would have it, as the correct test, a sovereign versus non-sovereign function distinction. Paragraph 6, we've made the point that I made yesterday about only 2 of the states being specifically about housemaids or gardeners, with the qualification about the third that my Lord Wilson raised, arising out of Park and Shin. And the final point, which is a new one that I wanted to emphasise, is that at paragraph 7, and that relates to the oddity of the United Kingdom's position in terms of assertions of immunity on behalf of the United Kingdom, because as we've indicated there, and this is a reference to a footnote in Professor Garnett's 2005 article, one of the articles that is before the court, the United Kingdom's instructions to its own missions abroad as long ago as 2005 was that before asserting immunity in response to any claims made against the United Kingdom's missions abroad, careful consideration should be given to the position of the employee and whether or not he or she was performing a public function. So certainly so far as the United Kingdom's practice is concerned, there's been no difficulty with opting for a solution of the kind we contend is consistent with state practice generally. So that is the state practice document, or the assertions document. The second document is the supplementary note on Article 14, and I hope goes some way to making clear the substance of our position on the questions of justification that my Lord Wilson was raising with me yesterday. And for that purpose, I wonder if I could ask the court to turn up where the Secretary of State deals with this question in his printed case, which is at MS 249 and following, from paragraphs 142 onwards, and in particular MS 250, where the first of 5 arguments by way of justification for section 42B is set out. And what we've done in this note is seek to address each of those 5 arguments in turn and set out clearly what our position in relation to each of them is. And we've started at paragraph 2 with the 3 broader, what we submit to be overarching points that I sought to summarise yesterday, and I won't go back over those, but you'll see them set out there. So the Secretary of State's first argument is based upon Dr. Yang's summary of the nature of restrictive immunity. This is paragraph 145, and it was the subject of an exchange between my Lord Sumption and Miss Stain when she was on her feet yesterday. And the 2 elements that Dr. Yang identifies, commercial and private in nature, and connection with the territory of the forum. And now Dr. Yang has based that, as we see from the references we've given there, from his analysis of the law of the United States and of Switzerland. We have no particular difficulty with that as a summary insofar as employment claims against states are concerned, and indeed it's reflected in Article 11.1 of the UN 2004 Convention, where both elements are reflected. The short point we make in response to it is that we've set out at paragraph 4. There manifestly is a connection with the forum state in Miss Janah's case. The work she was contracted to perform was to be performed here. It has been performed here. She was dismissed here. On her case, she was unlawfully treated here. At the time of her dismissal, she had been employed here for more than 6 years. She was a member of the local labour force throughout that period in a manner which we say entirely justifies the United Kingdom courts having supervisory jurisdiction over her employment. And it also well illustrates, we say, why Section 42B is not a remotely adequate tool for measuring that question of connection between forum, state, and employee. And that is essentially the point that we see the Court of Appeal as having made in paragraph 63 of its judgment, where it held that there was a sufficient jurisdictional link to the United Kingdom by virtue of the satisfaction by Miss Janah of Section 4.1 of the State Immunity Act. Section 4.1 of the State Immunity Act, as the Court will recall, is the one that requires for there to be no immunity, that the contract is to be performed wholly, or the contract is made in the United Kingdom, or the work is to be wholly or partly performed here. So that is where nexus and relationship to the forum states courts is dealt with. And that approach is, we say, entirely consistent, as we've said in the last sentence here, with Article 11.1 and 11.2a of the 2004 Convention, which, as Professor Garnett, we say, has cogently explained, are very clearly customary international law, whatever debate there might be about the exceptions to the exception. So that's point 1, paragraph 145 of the Secretary of State's case. Point 2, paragraph 146, the Secretary of State invokes the importance of the principle of sovereign equality as a justification for Section 4.2b and cites the jurisdictional immunities case. Now, again, the Court of Appeal, we say, conclusively answered this point at paragraph 63 of its judgment, and there is simply no basis for saying that Section 4.2b is a necessary response to any sovereignty concerns. And there's a further point which I'd like to add here, which isn't in the note, which perhaps demonstrates that all the more vividly, that if there is a response to sovereignty concerns in the State Immunity Act at all, it's that in Section 16, because it's Section 16 which is purporting to insulate at least some element of the diplomatic function. And as we've submitted yesterday, Section 16 does so in far too blunt a manner and in a way which leaves the United Kingdom way outside the norm. So we don't dissent from the idea that sovereign equality is an important principle and has some relevance to this analysis, but it's to be tested by reference to Section 16, not 42B.
Thank you.
The third argument is that at paragraph 147, and is potentially quite an important one, because it's the Secretary of State's attempt to neutralise the suspect category line of authorities and the need, if we're in suspect category territory, for there to be very weighty reasons by way of justification. I've touched upon this to some extent yesterday, but there are further points of detail that I want to emphasise here. Firstly, that at little a, the differential treatment here is at least in part a nationality-based differential, and that much is common ground between us. We say that is on the authorities sufficient to trigger the very weighty reasons requirement, and that is illustrated by the fact that the founding authority from a Strasbourg perspective in this context, UKSC, was also a case involving differential treatment by reference to both nationality and residence. The second point is that at little b, that on any view, as we've explained at paragraph 109.2, section 42b does have the potential to operate as a pure nationality criterion. The third point is that residence is also a protected category. And the fourth, that on any view, indirect discrimination because of the preponderant impact on foreign nationals would be in play, requiring justification. And the final point, which perhaps with the UKSC's point is the most significant in this context, is that on the basis of the public law project line of analysis, we're in suspect category.
Yes, you made that point.
Anyway. So that's the third point. Very weighty reasons are still required. The fourth point then is that set out at paragraph 148 of the Secretary of State's case by reference to the 1991 draft articles and the content of the explanatory report underpinning the Basel Convention. Now, so far as the 1991 draft articles are concerned, there are 2 points that we've set out at little a. The first one I've made repeatedly, I know, but those articles did not stand in that form for the reason of discrimination. The second point is that the justification for that original provision, which ended up being deleted, was to the effect that such a restriction was necessary to avoid a situation where an individual might opportunistically seek to change their nationality or habitual residence to seize jurisdiction. And that was rightly described, we say, by the Court of Appeal at paragraph 63 as quite unrealistic. That then leaves the explanatory report of the Basel Convention, and as to that we have first of all the point again that I've already made, showing that there's nothing in the case law to show the Basel Convention to be customary international law, indeed quite the contrary. And secondly, and this is a point that perhaps hasn't come out but arises out of the facts of this case, Miss Janah, not a Libyan national, being told that she has to go and litigate her claim against Libya in relation to employment occurring exclusively in this country. Not a realistic scenario, as the Court of Appeal found. And that then leaves only the fifth argument, which is that, as it's summarised at paragraph 150, nationality cannot properly be regarded as a suspect criterion in the context of international law, where such distinctions are commonplace, And there are three sources that the Secretary of State relies upon here: the Vienna Convention on Diplomatic Relations, and particularly Articles 37 and 38, the Al-Rawi case in the Court of Appeal relating to state-to-state assertions of diplomatic protection, and the 5 European Court of Human Rights decisions. Now, taking each of those in turn, we deal with the Vienna Convention at paragraphs 11 to 13 and make 4 points there. Firstly, paragraph 11, those provisions say nothing about the circumstances in which domestic staff should be able to bring claims in relation to their employment contracts, and we say it will be odd in principle if the enjoyment of some very limited immunities from the receiving or forum state should indirectly bar the assertion of rights against the employer state. The second point is that at paragraph 12, it's quite surprising that commentators of the distinction that we've set out there would not have taken this point or been alive to this point if it had any substance. Particularly surprising, perhaps in the context of, it's not mine, I'm relieved to say, particularly surprising, we say, in the context of Professor Denzer, where she's gone to the trouble of considering the interrelationship between the Vienna Convention and Article 11 of the 2004 Convention, and has not seen any difficulty or tension between the two. And then the final point that we make, obviously at paragraph 13, about the agreement of the 2004 Convention, and an illustration at the end of paragraph 13 as to the arbitrariness of results which would follow, as illustrated by the facts of Miss Benkharbouche's case. Because Miss Benkharbouche, as the Employment Tribunal judgment found, actually obtained indefinite leave to remain during the course of her employment, and so on any view would be outside Articles 37 and 38, and so they couldn't possibly assist in some way in restricting her access to court. Al-Rawi next, and it's a very simple point. That case was concerned with a discrimination complaint brought on behalf of foreign nationals formerly resident in this country and detained at Guantanamo Bay by reference to diplomatic representations that had been already made on behalf of United Kingdom nationals held at Guantanamo Bay. And the point that the Court of Appeal made was that those two categories were not comparable in that context because diplomatic protection inevitably rested upon a state being able to assert the rights of its own nationals. So it doesn't assist here. The Strasbourg case law next. I've touched upon this already in the course of going through Lord Bingham's speech in A and others, and that the points I made yesterday apply to 15A. 15B is the only non-immigration case from Strasbourg relied upon by the Secretary of State. And actually, once one looks at both the facts in that case and the outcome, it assists me rather than the Secretary of State. It assists me because it is another case, like Geigersu's, where both nationality and residence were the disqualifying conditions, but very weighty reasons were still held to be required. And it assists me because even in what was described as a resource-hungry context, those weighty differences were not made out.
Right.
And that then leaves only the final argument, which is perhaps part of the fifth argument, but is at paragraph 151 of the Secretary of State's case, relating to the content of Article 11.2e of the UN Convention on State Immunity, the 2004 Convention. And as the Court will recall, the point made against me here is, well, look, Article 11.2e still contains reference to nationality, so surely there's nothing wrong with it as it's applied in Section 4.2b. Again, the Court of Appeal dealt with that at paragraph 64, and it gave two reasons that we've set out at paragraph 17. Perhaps the most significant one is that set out at 17b, because as the Court of Appeal explained, and as the ILC report on the draft articles, which commented on this provision in its original form, explained, this provision was all about the particular bond between an individual and a citizen and their state of nationality. And in that context, it was said that there was a compelling basis for saying that the state of a citizen should have priority over other states. Now, that doesn't apply here and doesn't justify a term of the reach and breadth of Section 4.2b. So it's an inapt comparison. And so, for all those reasons, and as we've sought to summarise then at 19 and 20, we say that in the end there isn't anything by way of adequate justification, whether one requires simple justification and a less intrusive means test, or a fortiori if one requires very weighty reasons, as we say we do in this particular context. And so that is what we would like to say, my Lord, on the question of justification. And that leaves only the question of the Charter. And in that context, we've addressed that at paragraphs 111 to 115.
Yes, on
And the Court of Appeal deals with this at 69 to 85.
I mean, there's no actual issue on this, is there? It's common ground, isn't it? It stands or falls with the Article 6 point.
I think it's certainly that's the case as far as Article 47 is concerned, my Lord. There's a wrinkle in relation to Article 14, which I think I ought to draw to the Court's attention, but that's the case in relation to Article 47, certainly. Although I think Mr. O'Neill seeks to go further with Article 47. I don't need to and don't seek to.
You say on Article 14?
Well, on Article... before going to Article 14, and so I don't forget to deal with it, could I just address my Lady Baroness Hale's question about remedies that was raised yesterday in this context, as to which rights fall within the scope of EU law.
The SFI does actually say, doesn't it?
It does, my lady. And if I can give the references, it's dealt with in the EAT decision at MS 481, paragraph 55.
Well, we just need one place just to know what the facts are.
Well, I think that will do in that case, my Lord. The Court of Appeal's order, if you want the reference, is MS 403. So yes, then on the substance, as we say, if we're right on Article 6, we're also right on Article 47, and I think that much is common ground between us. We say if our arguments are right in respect of Article 14, then it follows that Articles 20 and 21.1 of the Charter are also breached. Now, there are 2 points that I want to acknowledge here, though, straight away in relation to that aspect of the case. The first is that although referring to Articles 20 and 21 at paragraphs 61 and 77 for the purpose of their general analysis of the discrimination case, the Court of Appeal did not make an express finding in relation to their breach when it addressed the matter at paragraph 81.
Thank you.
And the second point is that there is authority from this court in the form of at least 2 cases, Nolan and Nuasley, which are not in the bundles, to the effect that Article 21.2 of the Charter cannot be invoked by third country nationals, though there's no reason, we say, to apply that rule to Articles 20 or 21.1. Now, as to that, we say it's not necessary in the end for the court to address these articles if we're right about Article 6 and Article 47, because we get to the same destination. The fact that the Court of Appeal didn't specifically make a finding about those articles, we say, though, should not dissuade the court from doing so if persuaded that we're right about Article 6 and 14. There's no issue as to remedy if we're right about all of that. And so the Court of Appeal's approach, as set out in paragraph 85, would follow. My Lords, my Lady, unless there are any further questions, that was all I was going to say.
No, thank you very much indeed. Very clear, Mr. Rotley. Thank you. Mr. Luckhurst. Mr. O'Neill.
Obliged, my Lord, my Lady, my Lords. I also have been burning midnight oil and produced a note which I was going to speak to because I have a very limited time, and the note, I don't know if it's been handed up yet, Lords. It hasn't. Just have that passed up.
Yes, come and collect it. That's very helpful, thank you.
It looks longer than it is because it, in fact, takes quotations from the authorities that I was going to be referring to, so I can go through it fairly quickly. I have also handed up a number of authorities, and there's also one coming up as well. That's simply for future reference, in the sense that, as I say, the full quotations from those authorities which I've handed up are in the speaking note.
That's very helpful.
So, so I'd hope, therefore, I can get through this within my, certainly within the 45 minutes, and perhaps sooner than that, depending on how the court feels.
So we've got speaking note for the centre and the judgment of the court in the Book Alpha case.
That's,
Thank you very much.
There were also 4 authorities sent up yesterday.
Yes, you're quite right. We've got them here. Thank you. Demir and Turkey and 3 others. Thank you. And they're the ones that are quoted.
Everything is quoted in this book.
But if we want the full text, it's there.
It's there.
Thank you.
On that, as I say, the Air Centre formally adopts the written submissions before this court. In general, we support and endorse the statement by the respondent on the matters, but mindful of the need to avoid duplication in these submissions, I simply wish to highlight certain matters which have arisen in the course of discussions before this court.
That's very helpful.
The general observations I start off with is of course, given that I'm appealing for an organisation called Advice on Individual Rights in Europe, my focus is very much on individual rights and on the European aspects. That's both the European human rights aspects and the EU law aspects. But it does seem to me that, in a sense, I come from this from a completely different angle from where the Secretary of State has approached things, and I think it's perhaps helpful to set out why it is and what it is, that different angle, why that has occurred. But as I say at paragraph 2.3 of the speaking note, it seems to be that the Secretary of State has approached this from, first of all, identifying that the defendant is a foreign state, the defendant in the, or respondent in the proceedings before the Employment Tribunal is a foreign state. And therefore, given that a general rule of customary international law comes into play, which is that except in limited circumstances, a foreign state cannot be arraigned before the domestic courts of this country unless it consents to that. It is then said that none of the claimant's cases fall within the limited exceptions recognised under customary international law as implemented in the UK by the State Immunity Acts. Therefore, say the Secretary of State, the cases must be dismissed from the outset without consideration of their merits. They deal with the European Court of Human Rights case law, which looks contrary to that approach by saying, well, they just got customary international law wrong, and you don't have to follow them. Similarly, we see with the case of Mohammedia, that got customary international law wrong. It was acting beyond its competence, and therefore has not to be followed. I say they're fairly radical positions which are not supported in anything in terms of how EU law functions. And if they were going to be pressed, it would require this court to make a reference to the Court of Justice under Article 267. However, I say the court doesn't need to do that, not because the issues raised by the Secretary of State in relation to Mohammedia are act clear, but because the issues of EU law, which are undoubtedly raised in this case, are determined by the fact of the application of Article 47 of the Charter, and that is Act Clear, and that is why this case can be determined without a reference under Article 267. And the reason I say that is because of the approach which we take, starting off from the individual. As I say at paragraph 2.4, our position is we have claimants who've lodged claims before the employment tribunals timelessly. There's no doubt that the employment tribunal would in principle have jurisdiction to hear this matter, which is to do with an employment contract which is being carried out within the United Kingdom. It's common ground between the parties that some of the claims at least are derived from or fall within the ambit of EU law, namely the race discrimination and harassment on racial grounds claims and the breach of working time. There's no doubt about that, so we know we're within the ambit of EU law, at least in relation to those claims. If you're within the ambit of EU law, then it's dead simple. Article 47 can be prayed in aid. Article 47 says, in terms, everyone, that's the important part, everyone whose rights and freedoms guaranteed by the law of the Union are violated has the right to an effective remedy before a tribunal in compliance with the conditions laid down in the article. So we have that right. That's what EU law says, at least for those claims falling within the ambit of EU law. Perfectly simple. If and insofar as any provision of national law, a statute or other kind of provision, prevents that right being realised, then it falls to be disapplied. That's a simple application of the normal constitutional rule which was spoken to by this court in Miller. And I quote the relevant passage there, which says that following the coming into force of the 72 Act, the normal rule is that domestic legislation must be consistent with EU law. In such cases, EU law has primacy as a matter of domestic law, and legislation inconsistent with EU law is from time to time, is to that extent ineffective in law. And that's it. A simple, straightforward case of the application of the primacy of EU law in terms of the right to a remedy for those rights which fall within the ambit of EU law. That's the normal rule of the Constitution, as it currently stands at least, which was applied by the Court of Appeal in this case. And it's and that's an end of the matter. So I'm afraid from the perspective that I'm coming from, so much of this incredibly impressive scholarship in this case is unnecessary, because Article 47 is clearly applied and clearly means that the State Immunity Act is disapplied, no matter the general state of customary international law, whether it be right or wrong. The Court of Appeal makes a separate order in paragraph 3.2, and again it correctly found that sections 40b and 16.1a of the 1978 are incompatible with Articles 6 and 14. And I say there's nothing which the court has heard should in any way lead it to overrule that declaration of the incompatibility of those provisions with those two articles. But
so
dealing...
all right, Mr. O'Neill, where does state immunity come in at all?
At some levels it doesn't. State immunity is simply another provision, in terms from the EU law perspective, yes. All it is the State Immunity Act. It's another provision of a Westminster statute, which, if applied in this case in terms of the EU law rights, would breach Article 47.
No, what I meant to say was, and I didn't, where does international state immunity law come in on your simple analysis?
On my simple analysis from the EU law perspective, it doesn't need to come in because it's Article 47. Any kinds of immunity, whether it be state immunity in international law or otherwise, don't need to come into this. And because EU law has primacy, and it has primacy on its own terms, not only in terms of domestic law, but as we see in the Caddy case law and in so much of the case law on the potential for the EU entering into other international agreements, EU law has primacy over those.
That does not seem to have been the view of the ECJ and Mahamdia. No. They took some trouble to inquire whether international law really did require immunity to be granted.
Absolutely so, and that's a point which I'd make too. There's the ECJ is an international law court. It is careful to found itself within the context of international law, and it looks at and applies and determines issues such as what is the customary international law in any particular issue, or what is required generally as a matter of treaty law.
Yes,
but when it comes to...
It hasn't gone as far as your submission does.
No, when it comes to the question of the primacy of EU law, fundamentally, when those issues, and those issues arose in Caddy in particular, as the court will recall, in terms of whether or not EU law had to give way to the Sanctions Committee decisions from the UN and aspects of the UN Charter. It said, when it comes to fundamental rights, then the ECJ is the guardian and EU law's autonomy has to be protected in those terms. So, yes, it does look at international law. Yes, it is wholly competent to understand international law. But when it comes to the crunch in terms of the protection of fundamental rights as a matter of EU law and the autonomy of the EU legal system, that's what trumps matters. That's what sets primacy. But I go into my section then on taking full square the Secretary of State's analysis. First of all, to the effect, did the European Court of Human Rights misunderstand customary international law and state immunity? I say the short answer to that is no, for all the reasons set out by the respondent. But from a more general point of view, eventually the digging has to stop. One, it's all very well to say that the European Court of Human Rights got it wrong once, but that it got it wrong 5 times in Grand Chamber and subsequently. There is a principle, as I think the Secretary of State accepted, of finality, of legal certainty. And of course, any final decision of any court can no doubt subsequently, with the benefit of hindsight, be criticised for the manner in which it ultimately reached its decision. This court would not be immune from such criticism. But the point is, finality is part of the structure, part of the values which the legal system observes. More generally, and again, I'm coming from this perspective of advice on individual rights in Europe, is that so much of the approach is from the Secretary of State to international law is terribly old school, pre-Nuremberg, as if international law were simply a matter of compacts between sovereign states out there in the international ether, rather than directly impacting upon the rights and obligations of individuals. EU law has changed that clearly in terms of its notion of a supranational legal system with direct effect. But of course, human rights, international obligations, and international human rights courts have also changed that vision of international law. Because what we have developed, particularly in the European human rights space, to use a notion which combines both the Council of Europe and the European Union, is that the law is a higher source, which is supranational in the sense of binding states within that European human rights space. So the old concerns of one cannot have one state being subject to the courts of another state because that is somehow an affront to their equality, as it involves a notion of subordination to that other state's laws. That doesn't apply when it comes to human rights aspects, because human rights apply supranationally within the European human rights space. They apply to all states. By being brought before the national courts of one country, that is not to say that a foreign state is being subordinated to the laws of that country, rather that that foreign state is like this state itself, whose courts it is coming before, is subject to those general principles of human rights, fundamental rights protection, protected commonly within that common European human rights space. So that's why, as I say, there seems to be this non-meeting of minds, completely different narratives which are going on as between the Secretary of State and what I say on behalf of the Air Centre is the more appropriate approach. Dealing specifically with the question as to whether or not there's non-engagement of Article 6, again, I say that idea that Article 6 is not even engaged requires a rather odd approach to the notion of when a domestic court has jurisdiction to hear a claim. Because basically, as I understand it, we are clear here that there are substantive rights which are claimed in this case against unfair dismissal, unpaid wages, deprivation of holidays, racial discrimination and harassment. All of those are substantive rights with a basis in UK law. But the Secretary of State says you start off from a position of the absolute immunity of a foreign state from all and any claims that might be brought against it before a domestic court. The Secretary of State says that the immunity is what the foreign state has, and unless the foreign state waives it, then the receiving court, the host country, has no jurisdiction. So it seems to be on their analysis, on his analysis, that it is the act of the foreign state which decides whether to invest the domestic state's courts with jurisdiction. They don't have jurisdiction, he says, because of the absolute immunity, but by a sovereign act, they will then invest the domestic courts with jurisdiction. Only once they've done that is there an engagement of Article 6. But I say that's not the case. Jurisdiction of the courts is determined by domestic law. Jurisdiction, procedural issues, which court can hear the claim, time limits in which one has to bring a claim, they're all aspects of what it is to have jurisdiction in a particular claim. Those are set out in domestic law. It cannot be the case that the waiver by the foreign state of its immunity involves investing a court, the domestic court, with jurisdiction it did not previously have. All it means is that the domestic court has the jurisdiction which it is given under in terms of domestic law and procedure, unless and until, after Article 6 is engaged, a valid claim for state immunity is made. So it's not a prior issue, it's not one of investment. Much was made of Germany against Italy and whether that made a difference, and it was said that the Strasbourg court should get an opportunity of looking at Germany against Italy and then realising the error of its ways and how it just doesn't understand customary international law. Once it had done that, then all would be well and the Secretary of State's submissions would at last be accepted. The court has, in fact, actually knows about Germany against Italy, as you might expect. It has referred to it. It has relied upon it. I've sought out there's a mention of it in the Al-Dulimi case, which is been produced, but that itself refers to the non-admissibility decision in 16 Mothers of Srebrenica against Netherlands. I haven't produced that, but I've got the quotation there. Germany against Italy is referred to and relied upon in terms the court knows about it. The court is very well aware of the jurisprudence on the sovereign immunity of foreign states when it comes to acta imperii. But the point is, knowing that, it still maintains its position in terms of the employment rights of those who are not acting in exercise of state power. So I'm afraid this is another case in which one refers to and relies upon Lord Rogers' Latinate dictum of Strasbourg having spoken and the case is finished. Said it often enough. Let's move on. Second point, importance of regional customary international law. Much was made of general international law, customary international law, but when we come to the European human rights space, what we are dealing with is an area in which regional customary international law is being constantly developed and looked at. When the European Court of Human Rights says we look to see whether there's a consensus within the European states, what it is in effect doing there is looking for the idea as to whether custom and practice has developed such as to allow it to have been developed into a norm or principle, legal principle, which is then applied within the jurisprudence of the European Court of Human Rights. It is constantly, in a sense, an engine and a focus for the development of regional customary international law, which applies within that European space. And the European Union, the Court of Justice, does much the same within the context of the European Union by referring again to general principles of law common to the member states, inspired by the constitutional traditions of the member states. So it too is developing an idea of regional customary international law. Just because the ICJ hasn't identified it is neither here nor there, because the supreme courts within the European space, the ones which are the engine and developers of that regional customary international law, are doing that. So really the criticisms that were being made of Strasbourg of not quite getting the details correct on various UN conventions and draft articles and the like are neither here nor there. And in any event, as the article, long quotation from the article by Alberto Alvarez Jimenez, points out that the International Court of Justice is no saint when it comes to how and when to identify general customary international law. It too has different methods. Sometimes it uses a strict and deductive method of checking as to whether or not all states have complied with the relevant rules. Other times, it uses the flexible deductive method, notably in the Nicaragua case, where the fact that a state practice is contrary to the custom doesn't mean that the customary international law doesn't exist. It means that the state is violating that customary international law. So, there is more flexibility in how you identify customary international law than perhaps even at a general level and was perhaps being allowed for by the Secretary of State. And in any event, regional customary international law is something which is well known and accepted by the ICJ in its jurisprudence. As I've said, that is a matter which one looks at how particular regions, and in this case the European region, is developing its custom and practice. It is clear that the Court of Human Rights in this case here has seen and developed perhaps that within that European space the customary international law is as it sets out in all of its case law from Al-Sabi and Kudak and the like onward. And that's because it can do that as a matter of regional customary international law. So, the long quotation refers to the role of acquiescence of states, and I'm not going to make too much of that, just simply it is of note in the quotation from the article, as I note at paragraph 320, that disparity of power between nations, so the idea of the equality, fundamental equality of states, is also modified within the determination of customary international law by seeing whether or not there's been some form of power play or coercion of one state over another. I say that none of those concerns need worry one within the European space. Lithuania cannot be said to have been coerced into taking a German view of customary international law. There's no suggestion of that. But I just think it's important that within that idea of the development and identification of customary international law rules, the reality of the need to look for and remedy, if necessary, a disparity in bargaining power is accepted at the international level. But of course, all this case is about is precisely a disparity in power between Ms. Janah, Ms. Benkharbouche, low-paid employees in low-status employment at very low pay, being denied the possibility of even coming to the court and saying their employers have violated their rights. If that isn't a disparity of bargaining power and of access to court, then nothing is. Regional customary international law, in any event, according to some authors, and I've quoted Professor Koskiniemi, the Finnish scholar, says that regional customary international law, such as in the European space, can be said to be a lex specialis and would therefore have a higher normative status than general international customary international law. So we look to what Europe does and says, and we don't criticise it for not following, as the Secretary of State would claim, general customary international law. It is developing and applying regional customary international law. And it's perfectly entitled so to do. The case of how it has done so is classically the case in Demir and Bekkara against Turkey, and that's one of the cases I've produced. We don't need to go to it because the long quotation takes everything from it, but it's classically the first paragraph I've quoted. It notes, and it's a Grand Chamber decision. This was an issue about whether or not Turkey was in breach of Article 11 of the European Convention on the right for trade unions to meet collectively and the like. Turkey did not allow its own civil servants to be involved in trade unions and collective bargaining. And the issue was that in breach of Article 11. Now, classically, as part of that notion of the Iuri Imperii, the idea that the state is acting through its civil servants, then the employment of civil servants was not seen one which was covered by ideas of Article 11 or rights to collectively bargain or even rights of employment. Crown servants held their position at the pleasure of the Crown. And those ideas were there, implicitly there, when the European Convention was established. But things have moved on, says the court in Demir and Bekkara, and that the court has to take into account the practice of European states reflecting their common values. This is an example of what I've called regional customary international law. The consensus emerging from specialised international instruments may constitute a relevant consideration. And it doesn't matter if, in this case, Turkey hasn't ratified the particular instruments which the court refers to and relies upon for its explication of what is required now by Article 6. It will be sufficient, says the court, for there to be for the relevant international instruments to denote a continuous evolution in the norms and principles applied in international law or the domestic law of the majority of the member states, and show what is common ground in modern societies within Europe. So that's its general approach. Having taken that approach, it then says, frankly, everyone's out of step now, apart from Turkey, in terms of the treatment of civil servants. It is not enough to say that they are exercising the powers of the state and therefore should not be bargaining against the state. The fact is, the reality is that even members of the armed forces or the police are now in most European countries allowed to form trade unions and or have a limited notion of collective representation. So, but it says one has to look on the individual cases, and it comes back down to this notion of the functional aspect of the particular job. It's not enough to say you're employed by the state, therefore you have no rights. It's what functions do you carry out in your employment by the state, which determines whether or not one can properly be excluded from what would otherwise be common employment rights. That is an approach which has been taken consistently by the European Court of Human Rights and by the Court of Justice, in fact. And I then quote in the next section the Viljo Eskelinen against Finland case. Again, that's a case which is in the MS bundle, and I've given the reference for that. And I've quoted at length from it. This is Viljo Eskelinen is an example of where the European Court of Human Rights has followed the jurisprudence of the Court of Justice in terms of extending Article 6 to the rights of state employees to a determination of their rights and obligations. And in particular, it used to be said that Crown servants, functionaries of the state, didn't have civil rights because they were there at the pleasure of the state. Therefore, Article 6 didn't apply, but that was substantially redeveloped by the court in a case called Pellegrin against France, and then reaffirmed in the 2007 case that we have here. And it said in terms that it was following what the Luxembourg court did, which extended judicial control even to the police and members of the armed forces in relation to sex discrimination cases initially, and that although it was a legitimate concern as to whether or not there was an exercise of state power, it had to be shown in the particular circumstances of the particular post that there was really such as to justify the exclusion from the coverage that would otherwise be given under Article 6. So the last sentence, the last paragraph of at page 13 sets out the court's recapitulation. In order for the respondent state to be reliable before the court on the applicant's status as a civil servant, in excluding the protections of Article 6, two conditions must be fulfilled. First, the state must have expressly excluded access to the court for a particular category of staff in question. Secondly, the exclusion must be justified on objective grounds. We see the parallels immediately with the situation here. Although, again, it's that two-stage test. Has there been express exclusion of these employees on grounds of their relationship, not with the domestic state as civil servants, but with the fact that they are employed with a foreign state? That has to be justified on objective grounds. The objective grounds mean that the mere fact that the applicant is in a sector or department which participates in the exercise of power conferred by public law is not in itself to be decisive. In order for exclusion to be exercised, it is not enough that the civil servant participates in the exercise of public power or that there is a special bond of trust and loyalty. It's for the state to show the subject matter in dispute is related to the exercise of state power or that it's called into question this special bond. Thus, there can be no justification for the exclusion from the guarantees of Article 6 of ordinary labour disputes. That's important. No justification for ordinary labour. This is an ordinary labour dispute. And I say that that case law, the escalating case law, is of a completely compatible with and probably has well indeed informed the case law in Kudak against Lithuania. Because there is no iure imperii justification. If that functional approach as to what is actually done in the circumstances of the particular case, rather than simply saying you are employed as a member of staff at a diplomatic mission, then one could well see that individuals, vulnerable individuals, are deprived of all protection whatsoever. I refer briefly to the case of Hunga against Allen, the case of the illegal contract of a person who was brought over here in breach of immigration controls. That could easily be an individual trafficked or brought over illegally to work within an embassy situation as well. In fact, there's even a footnote to a Guardian article all about that. Moving on then to did the Court of Justice misunderstand customary international law? The short answer to that is that's not even a competent question for this court to rule upon. That is a matter for the Court of Justice. And so if the Secretary of State is serious on this, and I don't think he is, I hope, then we need to get perhaps what's going to be the last Article 267 reference from this court, which would be fun, but I don't think it's necessary.
I think it's unlikely to be the last, Mr. O'Neill.
Well,
we've still got how long? 18 months to go before the great repeal.
We have an election on today. We never know what might happen tomorrow, my lady. So let's act as if nothing has happened.
Yes, anyway, there's tons of case law, a lot of case law from the Court of Justice about Uri Imperii in terms of, because it's a term which is actually used in the Brussels Convention, as we've seen, Article 1.1 of the Recast Convention. So they're always looking at it. The most recent case looks at whether or not being sued for parking charges for illegally parking at a government building was an exercise of Uri Imperii. It wasn't, but it was actually raised. So, as I say, though, it's not necessary to make the Article 267 reference because the article, my analysis on Article 47 has answered it without going into the realms of whether or not Mahamdia got it wrong in customary international law. I say it most certainly didn't. Anyway, it got it right. It is in line with the approach taken in the European human rights space. Strasbourg and Luxembourg are walking, it's a bit like a three-legged race with them, but they are not subordinate to each other, but they walk hand in hand or tied leg to leg. Where one does something, the other usually catches up. So in this case, they are properly reflective of the regional customary international law, and there's absolutely no basis or reason either for this court not to follow their approach or to seek a reference on that specific point. On a point of detail, again, this is something I'm having difficulty understanding. Article 47 is an independent provision in and of its own self, which has to be understood within the context of EU law. This idea that it's somehow equivalent to Article 6, whether, at one point it said, well, it's just about the same, it doesn't really matter, there isn't a difference. There is a difference. It's a different legal system. It applies within the context of EU law, within the ambit of EU law. It is a specific right to a judicial remedy. It is not like Article 6. You don't have to find a right within domestic law, first of all, and you have a right to a judicial remedy, not a general remedy as in Article 13. It is different. And the Strasbourg Court itself says that. It says Article 47, in the context of European laws, I quote at 5.7, isn't confined to civil rights and obligations or to criminal matters within the meaning of Article 6. In this respect, the Charter codifies case law of the Court of Justice. So, we don't need the references to whether or not Article 6 is engaged or not. That's neither here nor there. All we need to know is, has somebody's rights guaranteed by the law of the European Union been violated or alleged to have been violated? If so, then you get a right to go to court to have that claim determined. So, let's stop talking about Article 6 and Article 47 being equivalent. They're not. They're like each other, they're analogues, they're cognate, but they're not equivalent. They're different legal systems. So stick with that, otherwise we're going to all get into a bit of a mess. And then I've quoted they're already there, the Diouf case and the Berlioz's case about Article 47 being different, broader than Article 6 and 13. And it's of a line with the notion of the autonomy of EU law that this court treats Article 47 in that autonomous way. One of the other cases I've just handed up is Berlioz's decision in the Grand Chamber, because you just had the Advocate General's decision before. It's a more recent decision. And again, I've highlighted in bold, so we can't miss it. Paragraph 54, the principle of effective judicial protection is a general principle of EU law, which is now set out in Article 47 of the Charter. Article 47 secures in EU law the protection afforded by 6 and 13. It is necessary, therefore, to refer only to Article 47. Stick with Article 47. That's what the Court of Justice Grand Chamber says in Berlioz. That's what I recommend to this court. So, and really it's just a point of niggly detail. The Court of Appeal referred to issues of horizontal direct effect when it came to Article 47. That's the wrong analysis. The right approach is that the duty is placed upon the court to ensure that all parties coming before it have access to it and an effective judicial remedy before it. It's not a question of horizontal direct effect, because that's to do with whether Libya has an obligation in some sense to Ms. Benkharbouche. This is to do with the obligations of the court to ensure, and the member states to ensure effective remedies and access to the court. So, as I say, if there is any suggestion about Article 47 giving lesser protection than Article 6, or somehow being bound to follow the lesser protection that Article 6 is said to have by the Secretary of State, then that is a matter for an Article 267 reference again. I say it's unnecessary, but there's the most recent opinion of Advocate General Kokot in a case of Pushkar. This is part of the ongoing spat between the Slovak Constitutional Court and the Slovak Supreme Court, who are constantly referring each other to the Court of Justice as part of a turf war. I don't know how you say that in Slovak, but in this case, the Advocate General Kokot has simply underlined that Strasbourg case law provides a baseline. EU law can go higher, so it's only if you've got any suggestion, if there's any possibility that the Charter is giving less protection than would be afforded under the European Court of Human Rights, that you then send that issue to the Court of Justice, which will make sure that all will be well and that the EU law will catch up with Strasbourg because it provides the baseline. But we're not in that situation. We don't need to go there, much as I'd like to. So, final point, last case, Bukalfa, which I've handed up, is simply, it reiterates the position under the nationality discrimination provisions. It's not directly in point, but it is quite parallel, quite similar. Bukalfa is a case in which a Belgian-Algerian dual national was employed in Algeria at the German embassy in Algeria, and the issue was, could she, as a Belgian dual national, claim the right not to be discriminated on grounds of EU nationality in terms of her employment by the German embassy, because she was employed as a local staff member on different conditions from Germans and the court. And it's an old case, it's from 1996, the court said almost absolutely certainly so. So if Ms. Janah or Ms. Benkharbouche had any kind of dual nationality with a member state, there's absolutely no doubt, just following the clear, again, Grand Chamber decision of Bukalfa, that the provisions of Section 4(1)(b) would have to be disapplied as contrary to EU law. But otherwise, as I've said, the position is Article 47 says everyone whose rights are affected has a right to a remedy. In this case, there's no doubt that the rights in terms of race discrimination and working time are in principle available to Ms. Janah and Ms. Bukalfa. That's also backed up, as Mr. Otti has been saying, by Article 20 of the Charter saying equality before the law is a basic principle of EU law, and Article 21(1) of the Charter, which is a non-discrimination provision which follows, although more up-to-dately, Article 14. So, but as I say, this can all be resolved from an EU law point of view without going into any of the issues as to who got it right on general international law, because Article 47 applies. You don't have to get into it from a convention point of view, because the Court of Human Rights has spoken more than often enough, and legal certainty and finality requires that this court follow it rather than critique it yet again. I think that's time.
Bang on time.
Unless I have anything else, that would be it.
Thank you very much indeed.
Thank you.
Mr. Otti, I see you've indented for another quarter of an hour at this.
Yes, I'm not going to use it, so you'll be pleased to hear, my Lord, but just three very short points, if I may. Firstly, whilst we're happy to embrace and endorse what's said about regional customary international law to the extent it helps us, and we've touched at paragraph 23.2 of our printed case on the significance for the narrowing of a margin of appreciation of a European consensus, I would like to emphasise that we don't need to get into concepts of regional customary international law for Ms. Janah to win. As I've been submitting, we have all regions of the world represented on her side of the line on state practice. We have a complete absence of competing case law and almost a complete absence of equivalent legislation from anywhere in the world. We have the position supported by the International Law Commission's Working Group and the Sixth Committee of the United Nations, each of which is consistent with Ms. Janah's approach. And we have the adoption without a vote, because of the level of consensus, by the General Assembly itself of the 2004 Convention. The second point is not an entirely flippant one, but it sounds like that when I say that we don't share Mr. O'Neill's enthusiasm or characterisation of the idea of a reference as being fun. It's not a flippant one because it was 5 years ago that my client was dismissed, and she wants to get on with bringing her claim.
Look, as far as a reference is concerned, we don't refer unless it's our duty to do so. And if it is our duty to do so, we refer.
My Lord, yes.
Story.
You have our submissions on why it's not your duty.
Yeah.
And the third point, which is a factual point that arises out of the last authority that my learned friend drew attention to, and it's in fact not Miss Janah's case, but so the court is aware of the full factual matrix. Miss Benkharbouche, in respect of whom you'll recall the Section 42B issue has not yet been resolved at first instance, has not only obtained indefinite leave to remain, as I submitted this morning, she's also now a British national. And so she would be able to invoke that Article 21(2) provision in any event.
Thank you.
Those are the only additional points I wanted to make.
Thank you, Ms. Brodie.
Thank you, Mark.
Ms. Stein.
Thank you. Might I begin with a request? We've had quite a lot of materials, both authorities and notes and so on, overnight. And I don't make any complaint about that, but whilst I would intend to respond as far as possible to the points that my learned friends have been making, particularly to Mr. Rossi's submissions, it would be helpful if we were able to put in a responsive note ourselves.
How long would you want for that?
Would 4 weeks be possible?
No.
No. We will take what we're given.
2 weeks, I think, would be
2 weeks.
on the generous side. Yes?
Thank you.
2 weeks. I think, obviously, copies to the other side. I think, in fairness to Mr. Otti, I think he should have the right to reply if there's anything which really is new, but I would discourage him from doing it. But I think it's the fairest way to hold the ring. To give you that extra 2 weeks and shut him out would be wrong. So play it by ear, but I think, Mr. Otti, on that basis, you've got a week to reply.
Understood, my Lord.
And keep it to a minimum.
Of course, my Lord.
Thank you.
Thank you,
Yep.
Mr. Rossi identified what he suggested were 6 errors in the Secretary of State's case, and I propose to take those in turn and address them. The first was an alleged error concerned with engagement, and this I can deal with relatively briefly. As to that, as I said in opening, if a state takes an idiosyncratic approach in identifying the circumstances where a foreign state enjoys immunity, then the restriction on access imposed will engage Article 6. So that's not in dispute. The question as to whether, properly understood, a grant of immunity within the margin engages Article 6 arises if the court agrees with the Secretary of State that the grant of state immunity in the circumstances of this case is within the margin of appreciation. And I've acknowledged that the answer to the engagement point is not going to affect the outcome of this case. And so the court, it would be open to the court to adopt a similar line to that taken in Jones and Saudi Arabia of not determining the point. But of course, currently, lower courts are bound by Holland and Lamp and Wolf. We suggest that if the court agrees with our analysis of the limitation on the scope of the right of access, and the point in the analytical structure where state immunity should be considered, then it would be helpful to say so. This is not a point on which there's any need for a reference to the CJEU because it doesn't affect the outcome. We've acknowledged the consistent Strasbourg case law on the point, but the reasoning does not go beyond identifying state immunity as being on the procedural side of the procedure-substance distinction. Now, we don't challenge the finding that state immunity is a procedural bar. Our point is a different one, which the European Court of Human Rights has not considered. My learned friend sought to pray in aid both Benkharbouche and Serdar Mohammed. Neither case provides any support for his argument in my submission. We entirely agree that Article 6 cannot create domestic law rights, and so Article 6 is not engaged where either Foreign Act of State or Crown Act of State doctrines are an issue, because those are substantive limitations on the scope of the domestic cause of action. But the point that we make is that the flip side does not automatically or necessarily follow. Even if a restriction can properly be characterised as procedural, there is still a question to be answered having regard to the underlying reasons for implying a right of access, whether that means Article 6 is engaged. And we agree with my Lord Sumption's description of state immunity in Benkharbouche at paragraph 282 as being a substantive rule of domestic law that has procedural consequences. And here we're in a situation where Parliament has both granted the statutory rights relied on and identified the limits of the court's adjudicative power in respect of such claims. And in my submission, the State Immunity Act does not in any way threaten the rule of law. That's it for engagement. Then the second in Mr. Rossi's list of our alleged errors is that we've adopted the wrong starting point. There are three aspects to this. Burden of proof, the correct approach as identified in the European Court of Human Rights cases, and also the correct approach in principle. As to burden of proof, in my submission, that concept is just not in point. My learned friend is seeking to erect a straw man to be knocked down. We don't accept it comes into play at all in this context, where what the court is doing is identifying customary international law. But even if it did, it would only impose a burden on us of showing that the general rule of immunity has not been eroded in this context by an applicable crystallised exception, a burden we can discharge without any difficulty at all. So in my submission, burden of proof just doesn't come into it when one's looking at which is the correct starting point. So then, looking at the European Court of Human Rights approach, how do they address these issues? In Al-Adsani, the court's approach was to consider whether there was a firm basis for concluding that the general rule had given way in the circumstances to an established and applicable exception. And Mr. Rossi's answer is to distinguish Al-Adsani and also the jurisdictional immunities on the basis that they concerned sovereign acts, and so prima facie state immunity applied. But in my submission, the European Court of Human Rights has adopted exactly the same approach and the same starting point in the context of embassy employment disputes, as it has in relation to state immunity cases concerning acts which are, on any view, acts iure imperii. And we can see this from three cases, starting with Fogarty, which is in Core Authorities, Volume 2, tab 14, and turning to page 37, which is at 1384.
Yep. We looked at this, didn't we?
Yes, and so it's, I mean, what we see, it's showing the approach that the court takes. It's finding that state practice is diverse. It cannot be said UK is alone in holding immunity attaches. It cannot be said that in affording state immunity, the UK falls outside any currently accepted international standards. So this is entirely consistent with our starting point, that there's a general rule of immunity, and the question is, has it given way to an established and applicable exception? And the approach taken in Fogarty when discussing proceedings relating to employment in a foreign mission is precisely the same approach as was taken in McKelleney. We don't need to turn it up, but that's Authorities 9, tab 57, 3790. And that case, as the court may recall, involved use of force by a member of the armed forces on foreign territory. So obviously, Jure Imperii. The court was using materially an identical approach to what we see in paragraph 37, as it's taken in the employment context. I'd also refer to Jones and UK. This is tab 18 of Core Authorities, Volume 2. And paragraph 190. Now, Mr. Rossi says of Jones and UK that, like Al-Adsani, it involves sovereign acts, and that explains, he says, the starting point. But what we see in paragraph 190 is that the approach being applied it's being applied consistently across all the state immunity cases, including, and the first in the list, embassy employment disputes. And each of the embassy employment cases, like Al-Adsani, McKelleney and other cases, concerned, as the court puts it, in the middle of paragraph 190, each of these cases concern the extent to which the former absolute notion of state immunity had given way to a more restrictive form of immunity. So in examining the question, the court was looking to see whether the forum state's view that in the circumstances, the general rule of immunity had not given way to an established exception was idiosyncratic. That's essentially what it's saying in the various formulations that we see in paragraph 190. Mr. Rossi gave references to 8 cases from Al-Adsani right the way through to Radunovic. You may recall, but without going to them, he gave you a number of references which he suggested support his case on the starting point. But in fact, nothing more is contained in those passages than the identified test that we've seen on numerous occasions now regarding measures that reflect international law not being disproportionate, and then we see ultimate conclusions as to whether the margin of appreciation has been exceeded or not. So in my submission, if the court looks at those references, there is absolutely nothing in them to support my learned friend's case or to undermine ours as to the approach the European Court of Human Rights takes. And in my submission, if the European Court of Human Rights approach is applied to the Court of Appeal's entirely correct finding that state practice in respect of state immunity is nowhere more diverse than in our context, then the only possible conclusion is that the legislature has not exceeded its margin of appreciation. And in my submission, the ECHR case law manifestly supports our approach and our starting point. Also, in respect of the approach, Mr. Otti says that the Court of Appeal took the correct approach in adopting the test it did at paragraph 20 of its judgment, where it refers to a requirement. And he says, in any event, the distinction between reflects and requires is a semantic one. Now, our objection to the Court of Appeal's requires test should not be misunderstood. I mean, we do say that reflects is the proper test as consistently applied by the European Court of Human Rights. Nevertheless, in the State Immunity Act, the legislature has not chosen to grant immunity going beyond circumstances where the UK considers states have a right to immunity. That isn't the way that it's been done. And if one looks at Holland and Lamp and Wolf, which is Core Authorities 1,
Yes.
tab 5 and 863,
Yep.
and between F and G, we see in Lord Millett's judgment his reference to the existence of the doctrine is confirmed by the European Convention on State Immunity, the relevant provisions of which are generally regarded as reflecting customary international law. In according immunity from suit before the English courts to foreign states, the State Immunity Act 1978 and the common law give effect to the international obligations of the United Kingdom. And our position is that the UK is doing what it considers is required. The key difference between the Court of Appeal's approach and that taken by the European Court of Human Rights is that in looking to see whether the UK is required to grant immunity, what the Court of Appeal has actually done, in effect, is to ask whether our view accords with the most restrictive, tenable view of state immunity. So the Court of Appeal is saying that diversity demonstrates a lack of obligation. So they're saying if some states can hold the view that state immunity doesn't apply, and if the conception held by those states of state immunity is a tenable one, then the UK isn't required to grant immunity. And so they're saying if there is a range of views, we're not obliged to adopt the view we have. In my submission, that is simply the wrong approach to the margin of appreciation and to the way that international law works in practice. By that I mean unless and until a specific rule of customary international law crystallises, different states may consider themselves bound by different obligations under customary international law. That's inherent in the way...
So which is the particular paragraph in the Court of Appeal judgment you're referring to?
well, I think paragraph 46 is the key paragraph. So my submission is that whilst they agree with us as to the margin of appreciation, they agree with us as to the tenable view test and so on, but it's the way in which they've applied it has the effect that they are saying if there's a diversity of views, then there's no obligation. And in my submission, that is a flawed approach.
Yes, I see.
As to the in-principle approach that we say, we say it is right to address the question whether the general rule of immunity has given way to an established exception which is applicable in the circumstances. Now, my learned friends seek to characterise the Secretary of State's position as being in line with China in asserting absolute immunity. Plainly, that is not the Secretary of State's position. The UK has long accepted that the doctrine of immunity is restrictive, but that doesn't in any way detract from our argument, because in accordance with the restrictive doctrine, the general rule is one of immunity, and that is then subject to certain established exceptions. And so the default position, the starting point, is immunity, and it's then necessary to address the question whether, as a matter of customary international law, an established exception applies. And that is the approach that one sees reflected in every piece of legislation across the foreign states when they legislate on state immunity. And we also, that's what we see in the Bâle Convention, in the 2004 Convention. We have a general rule and subject to exceptions. And in my submission, we're not here within the exception for commercial transactions. It might just be worth taking a look at the judgment of the Federal Court of Canada. This is...
well, we're not within that area because of the express proviso to that effect at the end of Section 3.
Well, that is
which
certainly
says
true.
That contracts of employment are not to be treated as commercial transactions.
Yes. In my submission, we wouldn't be there anyway.
But we don't need to go to United States jurisprudence to establish that proposition, do we?
Well, the point that I would make is that if we have our starting point of the general rule, we then have a question, well, would one, as a matter of international law, would we be within the international law commercial transactions exception? And in my submission, we wouldn't. And so one then has to look at the employment exception and whether or not that is applicable. Do you know the paragraph? It's, sorry, the question of who works within. Sorry, I'll come back to the case in a moment. But in addition to accepting in general terms that immunity is restrictive, the Secretary of State accepts that an exception to the general rule has developed in the context of employment disputes, and will I'll take a look at that in a moment, but just to follow up on the commercial transactions point, this is MS 5885. And we see the point made by the Federal Court of Canada that the question of who works within an embassy and whether they perform their responsibilities to the satisfaction of the foreign government is not a commercial activity. It is not a commercial matter, such as hiring someone to repaint the interior or to repair the plumbing. Rather, employment within the embassy is integral to its operations and is immune from review in domestic courts. And we say that when one's approaching this, the starting point is the general rule, and then looking to the employment dispute exception. As far as that is concerned, the State Immunity Act does not grant states immunity if they employ a UK national or habitual resident of the UK in any role other than as mission or consular staff. So, for example, if the French government employs members of the UK labour force to work at the French Institute in London, then France would have no immunity in respect of any employment claims they might bring. And equally, the State Immunity Act does not grant immunity where the employee works for an office or establishment for commercial purposes, save where the employee was a habitual resident of the employing state. The UK's position is that an employment exception to the general rule is established in those circumstances. It was being suggested we've made a concession in respect of an employment exception. Well, yes, we have. We concede that there is such an exception, but it cannot be shown that the employment exception has developed to the extent that as a matter of customary international law, the general rule is inapplicable to these cases. And in my submission, the restrictive theory of immunity does not import a simple distinction between acts iure imperii and acts iure gestionis, and no more, right the way across the board. That distinction is, of course, the focus in the commercial sector, but the broader position is more nuanced than that. In circumstances where disputes are brought by those who are or have been employed by the state or who have sought such employment, the distinction between iure imperii and iure gestionis has only ever been one element. Connecting factors to the forum or the employing state have been a key element in every version of the emerging employment exception. My learned friend, as I understood it, doesn't dispute that, but he suggests that the fact of working here should be enough, that's enough of a connecting factor. But the point is, it is an element, connecting factors are an element in the analysis of what the employment exception, of the scope of the employment exception, and as a matter of customary international law, it has certainly not been developed to the point where just because somebody is working in this country, that meets the connecting factor requirement. There's more to it than that. The commercial transactions exception developed in response to states stepping into the marketplace, acting as traders, and so on. As we've seen, the employment exception only began to emerge as states began, rather than bringing their entire retinue with them, to employ members of the local labour force. And in any event, in my submission, we are well within the margin of appreciation in saying that running an embassy, including the management and dismissal of mission staff, is a sovereign activity. The facts of Ms. Janah's case are illustrative of the sovereign nature of this activity. She worked in the ambassador's residence, including serving guests, at a time when the ambassador had been appointed by the Gaddafi regime. There was a civil war and the regime changed. Within a short period after the ambassador appointed by the new regime took up his post, Ms. Janah was dismissed. And as we saw in Article 9 of the Vienna Convention on Diplomatic Relations, if the receiving state considers anyone unacceptable, it does not have to give any explanation. That person can no longer work at the mission. The sending state's freedom to appoint mission staff is in Article 7 of the Vienna Convention on Diplomatic Relations. And the view of Denza that this freedom extends to a freedom to dismiss is a weighty one. And in my submission, it accords with a purposive and contextual interpretation of that convention.
Well, that wouldn't address the complaints, for example, about discrimination, underpayment, and so on during the period of employment. So it's at best, if you're right, only a partial argument.
I accept that element of it only goes to dismissal, to unfair dismissal. I do say more broadly that the management of mission staff is a sovereign activity. And I also point to the fact that we see in some of the decisions before the court that dismissal has been part of a reorganisation or a redundancy process or something of that kind. And in my submission, it's very difficult in those sorts of circumstances to draw a distinction between the freedom to appoint and the freedom to be reorganising who one is employing. And in my submission, it is obviously sovereign activity when states are engaged in working out who is going to be members of their staff in the mission. Mr. Otti observed that Denza does not have any difficulty with the terms of Article 11 of the 2004 Convention. In my submission, that would tend to suggest that she is interpreting Article 11 too broadly, much more broadly than Mr. Otti would accept. If I could take up Holland and Lampen Wolf again, that's Core Authorities 1, tab 5. And it's in the judgment of Lord Hope at page 857 by letter D. And he's here considering the position of the plaintiff, who was a university professor. And but what he's saying is the maintenance of the base itself was plainly a sovereign activity. And he refers to Lord Justice Hoffman saying this looks about as imperial an activity as could be imagined. In my submission, the same can be said of running an embassy. Then he says, at first sight, the writing of a memorandum by a civilian educational services officer in relation to an educational programme provided by civilian staff employed by a university seems far removed from the kind of act that would ordinarily be characterised as something done iure imperii. The same can be said here of the functions and duties of Ms. Janah. I would accept that. But regard must be had to the place where the programme was being provided and to the persons by whom it was being provided and who it was designed to benefit. Where did it happen and whom did it involve? And by letter G, we see he says that on these facts, the acts of the defendant seem to me to fall well within the area of sovereign activity. And in my submission, that it is an analogous situation where what we have is somebody working within the ambassador's residence. We have referred, I would just highlight in our case, paragraph 19, to the Empire of Iran case.
Yeah.
And just to highlight, the point being made there is that there is a general rule of international law, but its more precise content derives from the national law at any applicable time. And so, just as Fox and Webb are suggesting that state immunity is something of an amalgam of international law and national law, that's similarly the approach of the German Federal Constitutional Court. In my submission, what we have here is we do have the international law rule, and then when it comes to applying that, there is a margin of appreciation, and the approach being taken here of suggesting that effectively the state gets to determine as a matter of national law how the international rule applies. That has to be done within certain parameters, and so it's very close to the approach in respect of the margin of appreciation. And in my submission, again, applying the approach that one would have here in respect to the Empire of Iran, we are well within the margin. My learned friend then suggested that there was no material diversity. Now, obviously, we rely on the Court of Appeal as far as that's concerned. Very clear conclusions that that there is a great deal of diversity in the state practice in this area. Mr. Otti relied heavily on Article 11 of the 2004 Convention. And in this regard, he referred the court to Article 38 of the International Court of Justice, and in particular to the first subparagraph, where they identify international conventions and so on as being amongst the materials that they should apply. But Article 38 is there referring to international conventions where the general law particular expressly recognised by the contesting state. So what it's looking at is treaties which are in force and which are binding as between the parties. So where we have, as here, a treaty which is not in force and to which the parties to the case are not parties, then it will only be material if it can be shown to be custom. And as we understood his submission, my learned friend Mr. Otti doesn't contend that the 2004 Convention represents customary international law, but he nevertheless suggests that the court ought to give it very considerable weight. And in our submission, it's difficult to understand how one gets there to saying that something which is not customary international law should be given such weight. If it isn't customary international law, then in and of itself, it isn't relevant, save to the extent that the travaux préparatoires include evidence of state practice. So the process of agreeing the treaty may include evidence as to the views of states and so on, but the 2004 Convention itself isn't customary international law, and so can't be given the weight that my learned friend seeks to put on it. He also suggested, in respect of the travaux, that from 1982, sort of right from the outset, there had never been a proposal that would have had the effect of maintaining the immunity in respect of all mission staff. So the suggestion being that that is indicative of states' views that there wouldn't be or shouldn't be immunity in respect of all mission staff. And he referred to Fogarty at paragraph 19, that's Core Authorities 2, tab 14, 1379, and he suggested that the Grand Chamber misunderstood the commentary, and I won't take you back to it, but we don't accept that. On the face of it, the commentary is certainly broad enough to cover all mission staff. But in any event, we know that in 2002, there was still a proposal being put forward and discussed, which would have covered all mission staff. And so it's clear that that is evidence that certainly there were views on the part of states that was the possible scope of immunity. Now, the final treaty clearly doesn't go as far as Section 16 or Section 42B of the State Immunity Act, although I do say it does cover a case such as Ms. Janah's. But the fact that ultimately the treaty was agreed in a form that that doesn't go as far as those provisions doesn't take one anywhere unless you can establish, or it can be established, that the 2004 Convention is customary international law. My learned friend also tried to suggest that that the UK is alone in within Europe in having an immunity as broad as Section 16. But if one looks at all of the state evidence, in my submission, that's not right. One can see, for example, in NACU, which is in Authorities Volume 22, 261, SMS 79, at the top of the page, the Lithuanian Supreme Court taking the same approach, an approach which has the effect of granting immunity in respect of all mission staff. In relation to Article 11(2)(b)(4), if we could actually just turn that up. It's it's in Authorities Volume 1, and it's tab 4. Article 11 is at MS 841. And my Lord Sumption was asking Mr. Ossey how 11.2b4 should be read in order to in order for it to have the scope that he says it should have. And he said that one needs to read in to that subparagraph words such as persons attending international conferences. But in fact, if we look at 11.2b3, we see or is recruited to represent a state at an international conference. So that's already in expressly, and it wouldn't make any sense to read it in again to subparagraph 4. In any event, in my submission, in accordance with the Vienna Convention on the Law of Treaties, we don't get to the Travo when interpreting this provision because clearly it's not being used, the Travo are not being used to confirm the meaning reached by reference to Article 31. The provision is not ambiguous, and there is nothing unreasonable or absurd about the ordinary interpretation. We'd also note that we don't actually have a commentary on the 2004 convention as such. We only have the commentary on the 1991 draft, which in itself, as O'Keefe and Towns explain, has its flaws. So in my submission, one certainly can't rely on the Travo to displace the clear meaning, particularly as the clear meaning is less extensive than the option rejected in 2002. So it is in no way inconsistent with that rejection. And it should be noted, the Strasbourg Court has never considered this provision because all of the cases in the Fogarty-Kudak line have been in respect of local recruits who do not enjoy diplomatic immunities and privileges. So it's never been in play in any of those cases. I'll only from Mr. O'Neill sought to rely upon regional customary international law. We would simply note that it's quite clear that the court in Kudak and that line of cases is not in any way seeking to identify regional customary international law. It's seeking to identify general international law, but as we've submitted already, it goes wrong in doing so. The fifth point made against us was that we place excessive weight on the Bâle Convention. First, insofar as it is alleged that Section 4.2b is discriminatory, we do say that it's striking that the Council of Europe adopted this treaty and it has come into force, and they did so after the European Convention on Human Rights had come into force. And so it is important to recognise that this is a Council of Europe treaty, and so it is relevant. It's particularly relevant when one is looking at the discrimination aspect. We also rely on it because the European Court of Human Rights has itself done so. And the court will recall that the identification of an emerging trend in Fogarty was founded on a statement in the commentary citing Article 5 of the Basel Convention, as well as the State Immunity Act and other similar legislation. And it was that identification of an emerging trend in Fogarty which has then been extended in subsequent cases. And so we do say, whilst obviously it's just one factor, but it is of relevance in determining whether we are within the margin of appreciation. My learned friend also placed some weight on the relatively low number of ratifications of the Basel Convention. But as the court saw in McKellarney, that can't be taken as showing that those who haven't ratified it or signed up to it are unhappy with the grant of immunity in cases allowed by the Basel Convention. We saw in McKellarney, Ireland, one of the European states which has not ratified the Basel Convention, saying the court needed to understand that the reason states might not wish to sign up is because they didn't accept that state immunity was as limited as it appeared to be from the Basel Convention. So the lack of signatories or the relatively low number can't be taken as indicating state practice against us. The final point that was taken against us relates to the reliance upon claims by states to be entitled to immunity. And my learned friend sought to downplay this as, well, if it didn't carry the day, or if there was a lack of appeal or so on, then one shouldn't be placing any weight on it. But if I could take you to MS 5513. So this is the International Law Commission's guidance on the identification of customary international law. And what we see at paragraph 3, this is within their commentary to the conclusion 3, assessment of evidence for the two constituent elements. And at paragraph 3 on 5513, we see, starting a few lines down, moreover, the type of evidence consulted and consideration of its availability or otherwise is to be adjusted to the situation, and certain forms of practice and evidence of acceptance as law may be of particular significance, depending on the context. And then they cite jurisdictional immunities and the specific provision that we had identified, paragraph 55, where the court is saying in this context that we are dealing with state immunity, state practice of particular significance is to be found. And one of the points made is state practice of particular significance is to be found in the claims to immunity advanced by states before foreign courts. And so the attempt to diminish the relevance of claims to immunity, in my submission, cannot get him anywhere. It's clearly contrary to the proper approach to identification of customary international law. It was also suggested that the legislation in our favour hasn't been subject to a challenge, as though this diminishes its weight as evidence of state practice. And he relied on the constitution of Malawi, Pakistan and South Africa, which prohibit discrimination. In my submission, this is a bad point. The fact that there has been no constitutional challenge could equally, if not more so, be taken as indicating the view of these states that the provision is not discriminatory. In any event, the point is entirely speculative, and it doesn't diminish the relevance of the legislation as evidence of state practice. The final point I would make was just that there was a suggestion that that the state practice in terms of claims to immunity is diminished by the lack of cases going to the ICJ, that states weren't, as they had done in Germany v Italy, taking their points, if they had lost, to the International Court of Justice. But of course, going to the International Court of Justice is quite a big deal diplomatically, and it's not something that a state is likely going to do, particularly in the context of a small employment case. In my submission, it gets the one nowhere. The fact remains whether or not a state appeals or anything of that kind, that if they have asserted their immunity, that is evidence of state practice. My lords, my lady, those are all the points I was going to deal with, subject, as I say, to following up in a note.
Thank you very much, Ms. Dane.
Thank you.
Well, as you indicated at the end, we will have some written submissions from you probably, if there are to be any, within 2 weeks, with copies to those instructing Mr. Otti. He will have a week to reply insofar as he feels it's necessary and appropriate. Subject to that, then, we are grateful to you both and to Mr. O'Neill for your oral submissions. We're grateful to all those who were involved in preparing the written cases in this appeal, and we will take time to consider our decision and let you know it in due course. Thank you all very much. The court is now adjourned.